Commission meeting to order. And any changes to the agenda?
No agenda changes.
Is there a motion to adopt the agenda?
So moved.
Okay, motion second to adopt the agenda. All in favor, aye. Aye. Any opposed? Like to have approval of the minutes from February the 13th, 2012, or if there's any additions or corrections need to be made, I'd like to hear them at this time. Motion second, approve the minutes of February 23rd, 2012. All in favor, aye. Aye. Any opposed? The minutes are now official. Any council members in the audience? Please state your name.
Thank you, Mr. Chairman. Tim Garrett, council member at large, 1922 Tenon Road, Goodlettsville. First time in 21 years I've ever had to come and be before the Planning Commission on a conflict of interest, I guess is the only way I know it. But you have two bills, I think, on there that have to do with a PUD. And Mr. Vic Cunningham and his wife are here, and they're part of this. They own a condo next door. There are 14 condos next door to our house. Teresa, when you're in public office, the first thing you do is introduce your wife. Isn't that right, Stuart? My wife, Teresa, here. They're right next door. And what the Vic is president of the Homeowners Association. He had come to me and had worked out a deal with the developer to buy the 6 lots that are undeveloped in the HOA. There is 20 that are approved, and there are 14 there, and all 14 are occupied. And they were trying to find a way to buy those 6 lots, and so that there would not be any more condos built there. So that would be open space. The open space that is a part of the condos is right directly behind my house. There's an acre, about 1.5 acres or so, right directly behind my house. So Vicky came and said if they could sell off that portion behind the house, which is the open space for the condo units, then they'd have money to buy the developer out and use that portion that was going to be the 6 lots as the open space. Those are the 2 bills that you have before us. I wanted to let you know that I have paid for, which is a part of the deal that Vic and the members of the Condo Association have made with me, I guess, as much as anything. If I get this right, Vic, make sure that I have paid for all the fees concerning having this place zoned, any of the lawyer's fees, any of who is Tom White is handling that, and Roy Dale, former council member Roy Dale, is handling the survey part of it. And we've settled on a price, and I have taken that money and placed it in an escrow account in Tom White's office. So all of that's out there, but I want everybody to know that. I want to be right out front with everybody. I want so that whatever there is a conflict there, I have it. I will be, not voting on this at the council. Doug Pardue is the council member, and he's he's aware of it. And to my knowledge, there's not anybody that's against not building the condos that are there and having this open space revert back and go back to me. So that's it. Thank y'all.
Thank you for the confession. Any other council members in the audience? Seeing none, we will move along. And any items on deferral? I think we got 3, if I'm not mistaken.
Yes, we have 3 items on deferral. On page 4, item number 2, Beaumont Place, re-subdivision of Lot 37. It's a request for final plat approval to create 2 lots at 215 Manchester Avenue, and staff recommends deferral to March 22nd meeting at the request of the applicant. And then on page 5, item 5A, Percy Priest Drive. It's a request to rezone from CL to CS a portion of property located at Percy Priest Drive, approximately 1,075 feet west of Bell Road. Staff recommends, again at the request of the applicant, to defer indefinitely. And 5B on page 5, Larchwood. It's a request to cancel a portion of the Larchwood Commercial PUD Overlay District on a portion of property at Percy Priest Drive, about 1,075 feet west of Bell Road, related to item 5A. And staff recommends also to defer this one indefinitely. And that's the end of the deferrals.
Thank you, Commissioners. The been a request for item 2, 5A and 5B, as you've heard, to be deferred. Is there a motion for that effect? Motion second to defer items 2, 5A and 5B. All in favor? Aye. Any opposed? Those are now deferred. Councilor Johnson, if you'd like to speak,
Yes.
Yeah, we just got the next business, but I'll go back and allow you to speak now if you'd like.
Yes, is that okay?
Yeah, sure.
Okay.
This is just the council lady.
Good afternoon to all of the esteemed honorable commissioners. I'm Council Lady Karen Johnson, and I'm here before you in regards to the billboard public hearing bill that is before you. I also have to my left here an attorney who is distinguished in the Nashville community, Ms. Lorraine Wade, attorney Lorraine Wade, and she has worked with me extensively with this issue to address what was brought up at the last meeting in regards to the state law, which what was told was that this bill was in direct conflict of. The first thing I do want to share is many people from the community wanted to come today, but again, because of weather circumstances and because of the weather conditions today, many of them could not make it. However, I do have a couple of emails, one from a former planning commissioner, the esteemed and honorable Mr. Arnett Bodenhammer, and I want to read that to you, as well as give you a copy of that, and also another email that I received from another constituent that also wanted his statement read as well before I make my statement. And then Attorney Lorraine will also make
Councilor Lee, let me remind you, the public hearing was closed, but I'll give you the courtesy to speak for 2 or 3 minutes on this if you'd like, but not make a presentation. The public hearing has been closed. We closed it and deferred it one meeting only to find out, ask the attorney to find out about the state law that was in question. So just be as brief as you can, but you're the only one to be allowed to speak because the public hearing has been closed. But I'll give you the courtesy of speaking for briefly.
Okay, thank you. The first email, which is from Arnett Bodenhammer, he is saying here, I am writing to support Council Lady Johnson's request to have a public hearing process for moving billboards. This is a concern.
Let me interrupt you on that. I think we're getting in, when you start reading the email from somebody else, we may be getting into as if they were here and making a presentation. So I'd like to restrict it just to your comments, the pros, that you have on it, if you would.
I would also like to be able to, for the simple fact that I missed the last Planning Commission meeting, I was told that I could have the opportunity to share the concerns of people in the district who had expressed concerns to me. So many of these,
and you're welcome to do that briefly, but you need to paraphrase what they said and not read their email, because that's as if they were here. In my opinion, I'm going to make that ruling. So. Okay,
they are very short, and I only chose 2 out of the 8 emails that I received, just so that I could be brief about what I was going to share with you today. Okay. Again, Mr. Arnett Bodenhammer shared that I am writing to support Council. Okay.
Understand what I said. You cannot read the email. You can paraphrase them. But if you read it, I'm going to assume that that's the same as him being here, and that goes against the public hearing being closed.
Okay, I will paraphrase what they're saying.
Okay, please.
Apologize. And I will be submitting their statements as a matter of the record, the public record. I would like to have them included in that. Okay? Is that okay?
Yeah, but
Okay. Well, what I would like to ask then, since no one's comments can be shared as part of this process, what would I do to request that another public hearing be held for this issue prior to the council's public hearing in May?
Well, we're going to vote on this one today, so you very well may be that you're satisfied with that, but if you're not, then you, I guess you can take it on to the council and try to get 27 votes.
There is a procedure.
Well, you're assuming that that's
just-
going to be automatically denied, which I don't think that's a good thing to say. But I will just go ahead and
Okay,
submit, I'll just submit to you a copy of the emails from the two constituents. And I think also you have probably received a copy of the email that came from Attorney Cooper. And so this is mine, right? So this is what I'm going to say in terms of my statement. It's sad that the people and me as their representative, as the council person, has to prove that billboard companies are not grandfathered in. The burden is on them, not us as a metro government. Lamar and their representatives are solely relying on your denial of our opportunity to have a public input process, and the bill before you does not in any way flatly prohibit anything unlike the case that they are relying on for staff recommendation to deny the people to speak. Under the law, we have to protect the safety and welfare of the public. Outdoor West versus Johnson City, Tennessee, that Lamar keeps referencing, was a Court of Appeals case out of Knoxville, which is not this district. It was an Eastern Section case, not a Middle Section case, and the Court of Appeals in Middle Tennessee may not rule the same as what is ruled in the Eastern Section. Johnson City is not an MSA like Nashville-Davidson County, which is significantly different. This case does not apply to this case because it pertains to a denial of putting up billboards, period. The ordinance was in effect where it specifically stated no new billboards. It has to be proved that there is a zoning restriction, and the second is that the use in which they were using before was permitted before the zone change. So if they prove these things, then they can say they can come with it, then they can say they come within the bounds of the statute. If you choose to expand beyond, which in this case they would be, with a moving face type billboard, subsection C of the statute comes into play with what is before you. Also, subsection D, which talks about building and demolishing the billboards. The reconstruction, which in this case would be the changing of the board, which is necessary to such industry and business, meaning we have to do this because in our industry you have to do this to make money. The Johnson City case says that you cannot absolutely put anything up, and it was all around zoning. They were limited to a set number of billboards. They could not add any new billboards, and therefore they had to construct new ones. We are not doing this. To set up the process for Metro government to give the people an opportunity to voice concerns is not in violation or in direct contradiction to anything we have in place ordinance-wise or text-wise. TCA 137208 gives Metro government the right to put in processes or ordinances that are in the best interest of the citizens' safety and welfare. I close with the fact that the people should be able to have input before any decision is made so that all factors can be considered before any approval, especially in light of all the problems neighborhoods and citizens have expressed around billboards. They have a right to be heard and for their concerns to be factored into decisions.
Thank you.
Okay, thank you.
Doug?
Wait, that's what y'all didn't do.
Oh, I'm sorry. And items on consent.
Before we get to the consent agenda, for information for the audience, if you're not satisfied with the decision made by the Planning Commission today, you may appeal the decision by petitioning for a writ of cert with the Davidson County Chancery or Circuit Court. Your appeal must be filed within 60 days of the date of the entry of the Planning Commission's decision. To ensure that your appeal is filed in a timely manner and that all procedural requirements have been met, please be advised that you should contact independent legal counsel. Now, moving on to the consent agenda, items on the consent agenda will be voted on at a single time. No individual public hearing will be held, nor will the commission debate these items unless a member of the audience or a member of the commission requests the item be removed from the agenda, the consent agenda. So here are the items recommended for your consent agenda today, beginning on page 4. Item number 3, Gallatin Pike Auto Sales, a request to rezone from CS to SP for property located at Gallatin Pike, approximately 1,590 feet north of Walton Lane, to permit automobile sales, used, auto repair, and all other uses permitted in the CS district. Staff recommends approval of the SP with conditions and disapproval without all of the conditions being included. Item number 4, Dollar General, a request to rezone from specific plan mixed use to specific plan commercial for properties located at 541 and 551 Stewart's Ferry Pike to permit a 12,480 square foot retail use, replacing 20 townhomes and a 4,000 square foot warehouse that were previously approved. Staff recommends approval with conditions and disapproval without all of the conditions. On page 5, item number 6A, Tinnon Road. This is a request to rezone from RM4 to R40, property located at Tinnon Road unnumbered, approximately 750 feet north of Springfield Highway. Staff recommends approval. Item number 6B on page 5, Magnolia Station. A request to cancel a portion of the Magnolia Station residential PUD on property at Tinnon Road unnumbered, and to amend a portion of the PUD located at 1900 Tinnon Road to delete 6 dwelling units and convert the area to open space within the PUD, and to delete 1.42 acres of open space from the PUD. Staff recommends approval with conditions and disapproval without all of the conditions. And that's the end of your consent agenda.
Staff has asked that items 3, 4, 6A, and 6B be approved on consent. There's a motion to do that.
Excuse me, do we need to specify that we're approving them with conditions? Or just assume?
They're on consent with staff recommendation. Yeah. Okay. Items 3, 4, 6A, and 6B on consent. All in favor? Aye. Any opposed? Those have now officially been approved. For the members of the audience, the only item that you'll be hearing, and this is not a public hearing, they'll just be hearing the discussion from the commissioners, is item 1, which is a non-conforming static billboard conversion. And Doug, would you give us a opinion from...
Brenda, you want to go back over what this is about, or do you want me to just go right into the case?
If you'd go into the opinion first, because
okay.
that's why we deferred it to hear from you.
I had an opportunity to review the case that was cited in the memo that was given to the commission by Lamar Advertising that dealt with Outdoor West Tennessee, which is Lamar Advertising of Tri-Cities versus the city of Johnson City. And that case dealt with the destruction and rebuild of a billboard in Johnson City. And it dealt with the application of 137208, which is the state statute that deals with the grandfathering protections of nonconforming uses. And that billboard, several billboards qualified in this case as protected uses under the grandfathering statute. So 137208 did apply in those cases. And the council lady is correct. It's up to the property owner or the business owner to prove that they are protected under 13728. The grandfathering protections extend to their business. And in this case, they did to these billboards, and as the council lady pointed out, because in part, the entire county they had zoned the entire county so that billboards weren't permitted anywhere. So obviously every billboard that existed within that boundary were non-conforming uses. And so what Lamar sought to do was to take the billboards down and replace them. And that is protected under 13728, but under a particular section that says that you're allowed to destroy and rebuild a non-conforming structure that has a non-conforming use in it. And in this case, billboards are considered non-conforming. The building or the structure itself is a non-conforming use. You're allowed to destroy it and rebuild it as long as there's a business necessity for such. And then it goes on, and that's what the statute requires, that you've got to show that there's a business necessity for you to tear this down and to rebuild that structure that's a non-conforming use on the property. What it doesn't allow you to do, what it doesn't allow local government to do, is to deny that based on a greater adverse impact to the community. If that's not part of what the analysis is when you look at a non-conforming use as being destroyed and rebuilt. So that's why the ordinance that's before you is asking for a level of review that's simply not contemplated under 13728. If what you're doing is simply taking a billboard down and putting it back up within the parameters that are permitted under 13728, also has parameters about the size of the billboard that can go back up depending on the size that it was when it was taken down, and the lighting's the same, and you're not running into any other issues. You're just putting back up a billboard that has the same type of illumination. Then that's permitted as long as you can show a business necessity. And in this case, Lamar was able to show a business necessity because there was nowhere, as the court decided that because there was nowhere else in the county to put up a billboard, that created a business necessity for Lamar to be able to put this billboard back up. And in my mind, I can't say that I agree with the judges, but it is Court of Appeals here in Tennessee, and they said that was enough of a business necessity to not only allow them to put the sign back up, to put it back up with even a second face added to it. They didn't just put up a billboard with one single face, but they allowed Lamar to add a second face to that billboard. And that is somewhat similar to what we're dealing with in this ordinance, but there are distinctions. One, it's that was based on business necessity, whether or not they could prove that. And what this ordinance seeks to do is determine its impact to the community. And that's simply not contemplated in 13728 as a criteria that can be used to determine whether to grant them the ability to build that back or not. And I don't know if you have any questions about that distinction, but.
Stuart.
So you think the proposed ordinance as currently before us is not in keeping with state law for the reasons, for the actual wording that they've used in terms of what it would be evaluated for?
Yeah, I don't believe that I don't believe we'd be able to use that criteria to judge whether or not to grant a permit to rebuild a billboard. Its impact to the surrounding community, I do not believe, is a basis that we could judge whether or not to issue a permit to rebuild that billboard. Right. There are other issues that you could judge it by. I just do not believe that the one that's in this ordinance is one.
So it's not the concept so much as this particular wording, a particular reason. You believe, according to the analysis, that a public notification process could be established
Yes,
that could go to the BZA, but for very specific grounds in keeping with state law.
that's correct.
Okay.
You could do this. You could do the ordinance, you could go through the process that the ordinance has in front of you, but you've got to understand that the BZA couldn't deny them a permit based on the impact to the surrounding community. You can institute the process if you want to, with the understanding that it's a bit perfunctory. I mean, you go through that process and you've got to issue the permit regardless of the determination of the impact to the surrounding community.
But the BZA could evaluate on some basis, right?
True. They could. They
What
could
would
make
that be?
It would be whether or not there's a business necessity for that sign to go back at that location in this case, because they're changing it. Okay? So to tear it down and to build it back, and actually to tear it down and to build it back with those two faces, with a trifold, you could require that they show business necessity for that.
But that's not what's in this bill.
That is not what's in this bill.
I have one other thing, Mr. Chairman.
Yeah, before we get into discussion with the commissioners, I'd like for Rick to address to Council Lady the procedure. There's another procedure that you can go through.
Well, the request was, how do you get a rehearing? And basically, any aggrieved party or any commission member can request a rehearing within 45 days. However, the request must state what conditions have changed or what new information has become available since the original hearing that may serve as a cause for the rehearing. So there is a process that the Planning Commission has for a rehearing that's very specific, and I just wanted to make you aware of that.
Okay. Stuart?
I think,
Oh, you have a question?
I think because we do have information that's legal in context that strengthens the argument for the public process, I think that I should be allowed the opportunity as the public official representing the citizens to have the opportunity to share that information.
Well, but you have to make an application and then bring it back
We haven't
here.
made the decision yet, though. I mean, she's saying, well, anyway, I think there's been some misunderstanding about the fact that the hearing was closed and what that means. But my only further question about the case as part of the discussion, and we hadn't decided the case yet, so the rehearing may or may not be something that's relevant. I would like, Doug, for you to read 137208, TCA 137208.
You want me to just read it to you?
Yeah.
I have it.
I'm sorry, I didn't mean to make it look bad. I just figured that was the crux of the case. I know it.
How about if I just read the relevant parts?
As a lawyer, I've memorized it. But
Okay. Then I'll defer to you.
yeah,
Now, look,
you know what I mean. I don't.
Yes, no,
know how long it is.
I know what the portion, you want me to read the portion that I'm talking about in regards to when you can destroy and rebuild
Right.
non-conforming uses.
Right.
And I believe it's covered in B, yes. Yes, thank you. Just move it. Okay, in the event that a zoning change occurs in any land area where such land area was not previously covered by any zoning restrictions of any governmental agency of this state or its political subdivisions, or where such land area is covered by zoning restrictions of a governmental agency of this state or its political subdivisions, and such zoning restrictions differ from zoning restrictions imposed after the zoning change, then any industrial, commercial, or business establishment in operation permitted to operate under zoning regulations or exceptions thereto prior to the zoning change shall be allowed to continue in operation and be permitted, provided that no change in the use of land is undertaken by such industry or business. I apologize, B1's not it.
It's D. D as a dog.
I'll look at it and do it.
The the same language up to the point that it states that present facilities and reconstruction new facilities necessary to the conduct of such industry or business subsequent to the zoning change, provided that no destruction or rebuilding shall occur which shall act to change the use classification of land as classified under any zoning regulations or exceptions thereto in effect immediately prior to or subsequent to change in zoning land area on which such industry or business is located. No building permit or like permission or demolition, construction, or landscaping shall be denied to any industry or business seeking to destroy and reconstruct facilities necessary to the continued conduct of activities of that industry or business where such conduct was permitted prior to the change in zoning, provided that there is a reasonable amount of space for such expansion on the property owned by such industry or business situated within the area which is affected by the change in the zoning so as to avoid a nuisance to adjoining landowners. I'm sorry, that's still not the right section. Yeah. You'll give me a second to look at it myself.
Yeah, I'm sorry, I didn't know it was going to be tough. Give me a service in there.
Well, but I can get it on the Wi-Fi. The Metro Wi-Fi.
Okay.
I can't get phone service, but I can get email service. Trying to find out about this guy, Carla. She got the name.
research while on television.
I'm afraid this is hurting our ratings. I'm not sure.
Everybody switched over to something else.
I'm sorry, I should have raised this before, I suppose.
Well, I felt like I knew right where it was in the statute, but I'm having a difficult time finding it.
Your YouTube audience is watching.
YouTube, too.
Can we, Chairman, can I ask, can we do our historical commission, we go out of order with the other?
We could do
Take it out
that.
of order if you need a chance.
Yeah, we do that.
Historical 5 pages of statute.
We'll give you all the time you need. Yeah, sure, that's a great idea, thank you. Mr. Ponder,
Ready.
Historic Zoning Commission report.
This is Parks Board.
I mean, Parks Board.
Okay.
Hunter's not here.
It's not here. Yeah.
Yeah. Okay, Parks, there were a couple of pieces of business we brought up. One was a request from State Representative Gary Moore, who asked that we approve a change of a name on property acquired from the state of Tennessee located on Morgan Road in Jolton to Paradise Ridge Park, and it was approved. And then Bob Parrish gave us some information about a wetlands proposal, enhancements in Shorebird Ponds project at Bells Bend Park. Quite extensive. There were two proposals connected with this. One, in fact, both of them have been deferred until the Acquisitions Committee takes it up before our next meeting, which will be the first Tuesday in April. I'm chairman of that, so I'll have that responsibility to bring those up. But one of them deals with, I'll just read it. Staff requests board approval to proceed on a wetlands mitigation collaboration with the Tennessee Department of Transportation and the Friends of Bells Bend Park. This project is expected to involve 10 acres of land in Bells Bend Park and provide approximately $300,000 for this project, so a good-sized project. The other one, staff requests board approval to obtain the deed restriction, land use restriction as required by the Corps of Engineers and other regulatory agencies for the wetlands projects described in the Bells Bend Shorebird Pond feasibility study, which was from 2011 and already approved by the board. That's the report.
Thank you. Executive Committee report, we met Tuesday at 10 o'clock, and the staff will have a report on the status of the items that we discussed and ask them to check on them at the retreat. You'll have that next meeting? Okay. The legislative update, Phil?
For the past couple of agendas, we have led a charmed life and had a relatively short agenda. I think we're banking time against budget discussions that are to come later. But we did have a public hearing, and the only real point of contention was the discussion over the Franklin Limestone Road asphalt plant issue.
Executive Director's report.
Speaking of that case, we did receive a request for a rehearing, and that's under review by, in accordance with your rules, by the director and myself, the chairman and myself, and we'll report back. We do have posted now the static draft of the Midtown Plan. That's your cue, Catherine, to come forward and pass those out to all the commissioners. That's going to be on your agenda, on your March 22nd agenda for adoption.
Any changes from
There's not really any changes from what we talked about. One thing that this probably different from many of the plans is that it requests authorization to proceed with a rezoning in accordance with this plan, and we think that's going to be a very proactive approach. That rezoning would allow any property owner that doesn't want to be part of the rezoning to opt out if they want to. So it'll be up to them, but I think in most cases property owners will want to take advantage of that. Yeah.
Let me ask you, remind us again, how many council districts are involved in this?
3, right. There are 3 council districts. It's Council Lady Langster, it's Allen, and who's the third one? Oh, Gilmore, right. Yeah. The majority of it, I think, is in Lancaster's district, but does include others. So I think that's pretty much all that I have. We have been proceeding just for the commission. We've had a couple of really good focus group sessions with the Antioch plan. We've had one with Antioch High School and had one at Hickory Hollow, and good participation in those, and that process is underway.
And we had a good session this morning,
Right.
a breakfast session, and at lunch with the representative from Vancouver. It was very interesting. So, Doug, you ready?
I am.
Render a decision.
Turns out I did read it. I just so busy reading out loud that I didn't pay attention to what I said. I go back to, as the council lady pointed out, D1, 137208 D1. And it states that industrial, commercial, other businesses, and I'm going to do a little paraphrasing here, shall be allowed to destroy present facilities and reconstruct new facilities necessary to the conduct of such industry or business. And that's the key portion that I was talking about. They have to prove that what they want to destroy and rebuild is necessary to the conduct of their business, that subsequent to the zoning change. Then later in that same section, it states that no building permit or like permission for demolition, construction, or landscaping shall be denied to an industry or business seeking to destroy and reconstruct facilities necessary to the continued conduct of activities of that industry or business, provided that there is reasonable amount of space for such expansion. And it goes on to talk about that. But I would also point out that 13728I, and the sections go all the way through K. Subsection I states, notwithstanding subsection D, which I just read, any structure rebuilt on a site must conform to the provisions of the existing zoning regulations as to setbacks, height, bulk, or requirements as physical location of a structure upon the site, provided that this section I shall not apply to off-site signs, which is what is a billboard. A billboard is an off-site sign. So it essentially says that local governments can't impose bulk restrictions on the site to billboards. But that if they want to destroy and replace the billboard, they have to show that there's a business necessity for them to do such.
And presumably, a billboard's business necessity is to be a billboard and to advertise whatever it's supposed to advertise.
Well, that's its business.
Yeah.
Now, what's necessary to conduct that business is going to be fact-specific, I think. A billboard alongside an interstate where you've got a low-lying land alongside it, well, that billboard might have to be pretty high to be able to be seen by who your target audience. Another billboard we might not have to allow to be so high because it might not be in that situation as far as the topography goes. So what the necessity is, what it is that the local government's granting that billboard to do, I think in part is going to be fact specific as to what is their business necessity. In this case, that Lamar has pointed out in Outdoor West, their business necessity for expanding it was a financial one. They essentially said, we can't make it here as a business, we can't make it here unless you allow us to build this structure with two faces instead of one. And the Court of Appeal in the eastern section, as the council lady pointed out, determined that that was enough of a business necessity to allow them to expand that billboard in that manner.
Would you address that question about whether the Eastern Division would also apply here?
It does. I mean, the law across the state applies. As an attorney, I don't get to ignore the Court of Appeals in the eastern section or in the western section. It just means there's a different panel of judges that would sit and hear that case. But ultimately, if you have decisions that come out in the different districts that don't have the same basis in law for their decision, oftentimes that's what will lead to a case getting up to the Supreme Court and them hearing and settling that. But I don't know of any cases that are that say anything different than what Outdoor West says.
If we pass this and Lamar files a lawsuit, goes to court, is the court going to render their decision based on the East Tennessee decision?
I don't know what they would base their decision on. They would certainly take it into consideration. I have no doubt that they would address it if it were right on point. But I can't say that assuming for a moment that it went up to the Supreme Court, that they would not feel like that they have to decide it based on this, but they certainly would consider the decision that was made in Outdoor West.
Chairman?
Yes.
Is one way to say it that decision is instructive as the only decision, but it's not controlling. I mean, it is not controlling in the sense that another court could. It's not controlling in the sense that a Supreme Court decision is controlling on a lower court. Is that right?
Right. It certainly doesn't have the precedential value that a Supreme Court decision would have, but I think as an advisor to this commission and to the metropolitan government, I would suggest that we follow the case law that's in place. And in this one, it makes this distinction about business necessity.
Take Greg and then Phil Claver and then Phil Ponder.
Thank you, Chairman. I guess I have some more questions. Under the ordinance, Section 1F, does the ordinance, would it create another public hearing, I guess, in front of the BZA? Is that what, I mean?
Yes, it would create a hearing in front of the BZA, but the point that I was making is that the hearing in front of the BZA would to make a determination that under state law shouldn't be a distinction that would prohibit them from being able to, that would prohibit Metro from granting a permit for them to put that sign back up.
Okay, so it would create another hearing in front of the BZA. The BZA would hear it. Now, could they ever rule against a tri-face becoming a tri-face billboard based on what it says here, greater negative impacts to adjacent property owners?
No.
So okay. So to me, it seems like what we're creating here is another hearing, but they can never take action.
Another hearing that could not take action based on the criteria that's set out in this ordinance, in this bill. That's correct.
I'll ask staff if they would go to BZA, is there a fee for that hearing?
Yes, there is a fee. When I spoke with the chief zoning examiner, I believe he told me it was around $250. It's also about a 5-week process.
And what was the amount?
About $250. There's a fee, and then there's a cost for doing the signs and notices that the zoning office does.
So they would have to pay $250 to go to BZA for BZA to say, go do it. Is that correct?
That's correct.
Well, Mr. Chairman, I mean, just from my own, that seems like a procedural delay tactic. But anyway, thank you for clarifying that.
Councilman.
Under the current code and also state guidance, if a billboard is going to be taken down and put back, can it be put back with a different bulk than it had before it was taken down? Can it be?
When you use the word bulk in that way, are you saying that can it be taken down?
Could it be put back bigger?
It can be. It could possibly be put back bigger. The 13728 and yet another area within this very long statute.
We'll take a break.
In section H, it discusses how large you can expand a billboard when you are taking it down and rebuilding it. So the state has set out guidelines that would limit the size of the structure itself.
Can be significantly bigger.
Well, that's a significantly, I mean, I guess it's in the eye of the beholder there about how much larger that's going to be. But I'll give you a quick example. Any standard 30-sheet poster shall not be expanded to a size greater than any standard bulletin, which for the purpose of this section H means any off-site sign with overall dimensions of 10 feet to 14 feet in height and 36 feet to 48 feet in width. So the parameters are very specific about how large they can get.
Okay, well, what's behind the question is I understand what you said earlier. State law does protect the ability to take a billboard down and to put one back in the same place as long as it doesn't expand beyond where it was. Is that right?
To a degree, yes.
Okay.
That you can take down a billboard and you can put it back at that location without consideration of the local government's bulk standards for that site. Now, that protection for the billboard company is limited to the bulk standards for that site. So as our department has championed, it doesn't go beyond those bulk standards. There are other things like illumination standards, distance requirements that aren't bulk, and I think the director would probably agree with me that those aren't considered bulk standards.
Okay.
So,
okay, thank you.
Philip?
Let me carry bulk and bigger just a little bit further so I try to understand this. When we're talking about taking down a sign and replacing it, let's just say, for instance, it's exactly the same width and length as far as the size of it. But what if you go to from a sign that's just a flat sign, 30 sheet or whatever the size is, and then you want to put in a Tri-Vision, even though it's the same size, does that change the the value of that sign, or somehow or other that it's doing more of a job than it used to because you got 3 messages on there instead of 1? Does that come into play in this request at all?
well, just the fact that they're going from a static billboard to a trifold billboard, that alteration alone, if we had a standard that just said you couldn't do that, I suppose that we could enforce that. But if that's what we're saying, if we're saying that those are different uses, and you can't change from a static billboard to a trifold billboard in area zoned a particular way, then yes, I would say that we could probably enforce that and say that if what you had was a standard billboard at the time that we changed that statute now to say that you can't have a trifold, and then you tried to change it to a trifold later, I would say that we could prevent you from doing that, because that's not part of the bulk standards that are protected under 13.7208. And much like the illumination or the distance issues that I mentioned just a moment ago, if we made that distinction within our own ordinances, I believe that we could prevent them from doing that, yes. But we don't have that in place, right?
Right. I want to point that out, that there is no distinction in our ordinance between a single-sided billboard and a Tri-Vision. If you came in on a perfectly appropriate piece of property, it's exactly the same requirements.
Okay. All right. Here's the $64 question. After all this verbiage, legally, why should this be disapproved?
You can go through
this proposal that's before.
Legally, you could create this procedure, but I point out that it is a meaningless procedure, because at the end of the day, if the evaluation that the BZA is being asked to make is the increased adverse impact to the surrounding community, if that's not a standard that they can deny a permit for. So the permit would have to be issued based, if the evaluation's just being made on that basis alone.
I want to just clarify, because when Doug gave us the legal opinion, he basically said that. The legal opinion was that you could hold the hearing, you simply couldn't deny it. The planning staff recommended that as a policy call, that it made no sense to bring a property owner into a hearing that could not result in a meaningful change.
It's just make work.
Well, it seemed like it was just not appropriate for us to create a hearing where, from a policy perspective, that the board could not act to turn it down.
And require them to pay a fee.
Well, correct. That's why the staff changed its recommendation to disapproval.
Thank you, that helped.
Bill? And then Roger, I'll get back down to this end.
If there's, I would entertain a motion that we disapprove.
Okay. Is there a second? Second. Motion second. Andre, you have addressed it?
Well, we've moved on. I think that helped. If we can't follow a legal procedure that makes sense, it's uncomfortable to approve it. So I understand that. If it could be reworded somehow another way, we could revisit it. But the way it's worded, I think there's really nothing for us to do at this point, unfortunately. I mean, it just doesn't really seem like it could go anywhere. I was going to ask, are there other cases? Are there other cases that would substantiate this that we could talk about? But I think we've got a motion on the table, so let's not.
Jeff?
No comments.
Okay, we've got a motion second to disapprove. Stuart?
I think what I'm hearing is that it's pretty strong suggestion from staff that this particular language is not supportable, doesn't make a lot of sense. I just wanted to state that I think it makes some common sense for the community that there ought to be some way to evaluate billboards that move. But I'm not sure, I am pretty persuaded that that's not the law. I don't think it's at all unreasonable for this council member to think that there ought to be a procedure of some sort. It appears that the state law may preempt that. And that's why I'm going to support the motion, not because it's wrong, but it's because the specific language may not be supportable. I do seem to recall in the history of this issue that the council lady originally wasn't looking just at this right to hear, but to actually set out a bright line standard. Isn't that right? Mm-hmm. Isn't this the second?
Planning is the one who said, could you compromise and take that bill off the table, and we work with you and with the attorney, with counsel, to draft a bill that will at least give a public process. That was the only reason I took that bill off the table.
Well, it doesn't change the decision. It is an interesting twist, and I think now that she's tried to do it both ways, one, an outright prohibition, which I don't think is necessarily legal either, but completely understandable that a neighborhood might want to look at a multi-faced billboard. I just don't believe under either this language or her original language, we in Metro have the right to enact this. But that I wanted to make it clear that it makes some sense that we should.
We've got a motion second to disapprove. All in favor?
Aye.
Any opposed? Motion is disapproved. Any other comments from any of the commissioners? Stand adjourned.
Make it to your meeting.
Yeah, I'll be fine.